Hi. Yes, ma'am.
Yeah, Mr. Watson, this was the River Points.
Sure, I remember.
I think this way probably have more information on what's going on with this information.
Do we have TRS done in this case? What did they suggest?
So they were very much focused on his felonies and they didn't really make a commentary on requests for these cases. It's
What?
like, there was classes and stuff regarding like the charge upstairs.
Yeah, but they would have. Did they get it on Watson? They get a TRS. We did a TRS.
Yeah, I think they put
If you don't mind.
a moderate risk.
I can find out, what was the first name?
Trevin.
Sure.
But I mean, basically the entirety of it, well, the recommendations at least for regarding the felony case.
It was what?
I think they recommended
Is that it?
IFS, maybe some classrooms. I think I got it on paper, I don't have it.
I'm gonna get it. Don't worry. Joseph, you got something quick?
I hope so.
What do you got?
My client couldn't make it today because his grandmother passed away and then his mother was subsequently hospitalized as a result of that.
Who's your client?
Julio Lopez. We were supposed to be entering a PTI today, but the VA's office sent me the PTI agreement on Thursday.
Is everything done?
No, because he had to go to Mexico and deal with this family emergency.
Just up and go and you have court? You can't just up and go, especially, I mean, really. What the flip? If I issue a warrant now and then he tries to come back, he's hosed.
I'm not saying that that's what I would have done, but he sent me a text yesterday saying all this happened and I'm in Mexico right now. So what I'm asking for is 1 week recess.
It's 200 days old.
But we have.
I wouldn't even. So I'm going to put him on, I'm setting it for bond forfeiture for Thursday. If he's not here Thursday, tell him I'm revoking his bond. It's not cool. You were supposed to get stuff done. You can't just up and go. I mean, really, especially international when you under bond conditions.
The funeral is going to be this week, so.
You can't just up and go when you have a criminal case, especially internationally, knowing that you have bond conditions, your case is over 180 days. Tell him I'm putting him on for Thursday. He's got to be here. Otherwise, I'm going to issue a warrant. You can always appear via Zoom, but really,
Okay, I'll let him know.
at the latest, I'll give you is Friday. But, yeah, I mean, actually, let's do Friday because Thursday's FIFA. So let's do Friday.
Okay.
If he doesn't show up by Friday. Okay. Thanks, Joseph.
Thank you.
All right.
But Mr. Watson, it
Yes, ma'am.
was recommended, I want to look for it. It was
Yeah.
recommended under self-conduct.
Great. I think that's,
Domestic violence,
Yep.
case law and this.
can I do ISF cognitive?
It was recommended for if it was needed.
I think that's a good idea.
I'm unaware of what ISM entails.
It's basically, it's an in-treatment.
It isn't treatment.
It's an inpatient treatment program, essentially is what it amounts to.
Inpatient treatment for what?
Um,
And cognitive behavioral issues to kind of teach you how to,
the cognitive behavior.
right.
For the student ones.
So you were asking how things should go. What I normally like to do is follow what TRAS recommendations are. If not, you can just set it for trial. But, you know, considering,
So you would not accept a plea
I would,
out of the ISF?
right, essentially. Because he's got 4 cases. He's got bond violation after bond violation after bond
I know,
violation.
Judge, which is why that we're here, we were supposed to have a hearing with Sentinel Tech about these stricter ones.
He's still in custody. He's on bond. I haven't put him in jail.
I know.
So I'm giving you the benefit of the doubt on that right now as we speak. But at some point, these cases have to finish up. We can't just keep them whole, open forever.
I know, Judge, I
And-
know. And like I repeatedly said, when we.
Our theft case is 250 days old.
And he's been willing to plead on that case for months.
So this is it. But, you know, when I have people on the docket who have many issues, I don't know how to go forward. Come up. Around this way. Here comes Mr. Watson, who's made a $100,000 bond, who we've given an appointed lawyer to, who has 1, 2, 3, 4, 5, 6, 7, 8, 9, another 4, and homeboy's got on a Gucci belt. It's probably like $600.
I know, Judge, I know.
Mr. Watson.
Talk about the Gucci belt, there are plenty of fake Gucci belts, but I understand.
Mr. Watson,
Sir, yes, sir.
let me give you some perspective. These cases need to be done. And I will give you to the end of this week to figure out what you want to do. But I have evaluations done for a reason, because
Sir, that's concerning my felony charge, not concerning my theft charge. And one of my theft charges, they have evidence that I did not do it. And I don't know why it's not being presented that the evidence that I did do. So the only thing that I really done it up is the original.
stop. You have the right to remain silent. Don't say anything, because whatever you say now, they're going to use it to prove your guilt. Just listen.
I'm admitting to the original
Stop.
charge.
Listen. While you have been on bond for your first theft case here, you've picked up another 3 cases. While you have been on bond for these cases, you have had a multitude of bond violations. I don't know how to go forward, but the only thing I know, stop. I want you to listen, because while you're trying to think of what to say, you're not listening what I'm trying to tell you, to impart to you. I am trying to figure out the best way to go forward, and I don't know. All I know are 2 things. Number 1, I want to protect my community. And number 2, you've picked up a boatload of cases within the last couple of years. So what we do is have you evaluated to see how best going forward. And what they recommended is ISF, which is an intersanctional facility with a cognitive treatment. Okay? That is what they're recommending. I am not an expert. I don't know. That's why we have clinicians on staff to tell us how to go forward when we have those who continue with.
Other than the ISL sprung from my felony charge. It wasn't just, that's.
You look, I, as a judge here, am within my right to accept a plea bargain or to reject. Okay? That is the job that we have here, in addition to try to protecting our community. Why we have people on staff is try to help us with a little guidance on how to go forward, so this stops before it becomes a 50-year sentence.
We never get to that because my cases are so, they have the definition.
Then I'm prepared now.
Recommendations other than ISL, sir.
If you don't have to do anything, but then what we will do is we will set your case for trial,
Go to trial.
and we will go to trial on all the cases.
I know
And if you're
I'm
found not
dead.
guilty, then you're found not
I
guilty.
know I'm dead to the wrong, Judge. Why
So-
would I take this case to trial when I have a case that's
Stop.
already being dismissed? I'm kidding. Judge, you know this doesn't make any sense. I have a weed case and a third case that I'm admitting to. I know I have a right to remain.
Man, get your boy.
I know, Judge, I know.
I am giving you,
It's time to think about if I'm gonna go to trial or if I'm gonna go to ISO. That's my
You said
option.
by the end of this week, Judge? Okay, you want me to think?
well, you guys go over all the evidence, decide what you want to do, but I'm giving you a heads up on what I think is appropriate considering all this that we have in front of us.
I still have a felony case to get.
Great. And the idea is to work out some kind of global resolution. But your case is 250 days and you're now on your umpteenth bond violation. Stop. I'm not putting you in jail now, but I'm putting the stop now because I'm tired of the violations.
The violation obviously is wrong for jury points. I didn't violate anything.
Great.
The technician.
That's why you are in the free world now and not in jail with a $100,000 bond. I'm not going to argue with you. I'm telling you how it is. I'm going to hold your ass in contempt. Go. Now I'm revoking your bond. Go.
Your Honor, I will say.
Nope. Go.
You just told me you was gonna give me, I'm trying to talk to you, Judge.
Sure. Go.
Just go for I just want to say we did reach out to Sentinel. And
It's over. It's over. I don't care. I'm just ready to put this, it's done. I'm ready to put this baby to bed. So he either, that's it.
How long is ISO?
I have no idea. It depends on them.
It's 45 days, depending on the progress, and I'm not 120 days.
Okay. Are you taking him into custody, Judge?
Totally.
I'll go talk to him.
Okay. Good morning, Mr. Ashmead. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 17th, 2026, in Harris County, Texas, a traffic crimes task force responded to a street takeover event posted on social media. Officer observed a motor vehicle do around 8 to 10 donuts in a pit of about 80 to 100 people, getting within 5 to 10 feet of striking people. Officers conducted a traffic stop on the vehicle. Independent, the driver was identified by his Texas driver's license.
So it is eligible.
Yes, Your Honor.
Mr. Ashmead, I'm going to find that there's probable cause to go forward with you. You said that, I didn't hear you say that he was the one driving. Did you say that or did I
Yes,
miss
the
it?
defendant was the driver of the vehicle.
Okay. I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to participate in these types of activities again. If you do, I will revoke your bond, put you in jail. No more PR bonds for you. Do you understand? Not only that, I will take your ability to drive away from you while this case is open. No more donuts, street takeovers, racing, reckless driving, anything of this nature. You are not allowed to drive unless you have valid liability insurance. You must maintain car insurance, and that is a condition of your bond as well. If you don't have car insurance, then do not drive. Do you understand? All right, we are going to reset your case to give you time to hire a lawyer. So I will have you sign a reset. I'm going to have you take a seat in the jury box, and we'll get your bond conditions. Once you sign them, then you'll be free to go. Good morning, Mr. East. Good morning. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On May 31st, 2026, officer observed defendant's vehicle while on patrol, traveling at 55 miles per hour in the 30 mile per hour zone. Officer initiated a traffic stop and made contact with defendant. Officer observed a strong odor of marijuana emanating from defendant's vehicle, and upon a probable cause search of the vehicle, discovered a black backpack in the back rear passenger seat containing a handgun with 8 rounds in the magazine. The backpack also contained green leafy substance consistent with marijuana. Upon a PCIC/NCIC search, the gun was stolen.
The gun was stolen.
Yes, Your Honor.
Mr. East, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to be in possession of any weapons whatsoever. If I find that you do, I will revoke the bond, put you in jail. No more PR bonds for you. This is not a revolving door. Do you understand? Does he have a license to drive?
Yes, Your Honor, it's eligible.
It is eligible? All right. How old are you, Mr. East? What do you do for a living?
Right now, cars. Yeah.
You're 19 years old and you do nothing. Do you just sit at home and twiddle your thumbs all day? What the hell do you do with your life, Mr. East? I don't know why you're laughing. It's not funny. You ain't got no money. You got no game, but you now got arrested and you got yourself a case. You ain't got me. No, you don't. You ain't got nothing. How do you even get money to put gas in your tank, Mr. East?
I did.
You what?
I work for my family. We have a hay business.
Okay. I asked you before, how do you support yourself?
That's how it's supposed to. So if you ask, what do I do for a living?
Correct. Meaning, what do you do for work? Job. How do you get money? What do you do for a living?
I work on that.
Do you earn an income from doing this? We are going to reset your case to give you time to hire a lawyer, Mr. East. When you come back, please have a lawyer. If I find that you have a gun, you endanger my community, it's not going to go well for you. Do you understand? Come on.
That's no weapon.
No weapons, no driving without insurance as well.
Yes, Your Honor.
In less than 1 year, Mr. Bex, unlawful carrying of a weapon, unauthorized use of a vehicle, burglary of a building, felony theft, 2,500 to 30,000, another felony theft, and now burglary of a motor vehicle, all in 1 year. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On March 9th, 2026, officer contacted complainant who informed him he had a clear video of the burglary of his vehicle that occurred that day. The footage showed a small white SUV pull up the passenger side and defendant exit from the rear passenger door of the SUV, and place face up against the passenger side rear window of complainant's vehicle, then break the window with the window punch. Defendant punches the broken window, reaches inside complainant's vehicle, then jumps into the vehicle. Defendant grabs a leash blower from the vehicle and gets back into the SUV with co-defendant and drives off. Officer was able to locate defendant and began conducting a rolling static surveillance on defendant's vehicle. Once defendant exited his vehicle, he approached a Ford pickup truck that was attached to a trailer. Officer observed defendant approach the backside of the trailer and cut the lock of the ramp door with a bolt cutter, then returned to defendant's vehicle. Defendant left and returned to the trailer location. Officer initiated traffic stop due to defendant not having a license plate, illegally tinted windows, and using commission of a crime earlier.
And what?
Officer conducted a traffic stop for not having a license plate, an illegally tinted window, and the use of the vehicle in a crime earlier.
Okay, so they knew it was him in the car?
This was after the officer was able to locate defendant, was conducting surveillance on him. Officer smelled the odor of marijuana from defendant's vehicle and asked defendant and co-defendant to step out of the vehicle. Defendant was located in the rear passenger seat. In the video, officer was able to positively identify defendant from the instant where the leash blower was stolen.
What time of day or night was this? And what about the co-defendant? Is there a co-defendant?
Checking off this report right now, Your Honor. We don't have a code connection, code dependent on this. I'll check the options report to see it. But they were able to get that.
I'd like to know also what time of day or night this was, so we can put appropriate conditions on Mr. Beck's.
So the officer learned that the burglary occurred around 11 a.m. or 11 p.m. Sorry.
One, okay? Mr. Beck, I'm going to find that there's probable cause to go forward with your case. I'm going to protect my community at all costs. If I have to make your bond $10 million, I will do it in a heartbeat. You will get a GPS monitor, and I'm giving you a curfew of 7 p.m. to 7 a.m. You will be tested 40 days from today. If you test positive for any marijuana, illegal substances, alcohol, I will revoke your bond and put you in jail. You are not to be in possession of any weapons, contact with the complaining witness in this case, or with the co-defendant in this case. Do you understand? You have 1, 2, 3, 4, 5, 6, 7 in 1 year, Mr. Bex, and they're all dangerous cases. It appears one of us has way too much time on their hands. Can you guess which one?
Your Honor, I'm sorry, the previous burglary of a motor vehicle occurred at 11 p.m. For this one in particular, we don't have a time, but officer was, this one happened at 10 a.m. And Your Honor, there are I'm still checking to see if there's any listed code amendments.
Can you give him an application for appointed lawyer, Deputy Williams, please? You are skirting extremely thin ice, Mr. Bex. I'm telling you now, if I deem you a public danger, I'm going to give you a high bond. Do you understand me? One false move.
Your Honor, from the office report, it doesn't look like they
Okay.
arrested anybody else.
Just hey, test 40 days from today, please. Hi, are you ready? Please.
Mr. Rivas Diaz, final reader. Bottom of page.
Do you need a translator?
No, Your Honor.
Okay, come on up, sir. All right, good morning, sir. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On May 31st, 2026, in Harris County, Texas, officer observed a vehicle on McKinney Street with a defective license plate and playing extremely loud music. Traffic stop was conducted. An officer made contact with the defendant and observed the strong odor of alcohol separated from the vehicle, bloodshot glossy eyes, and slurred speech. Officer observed an open container was inside the seat pockets on the back of the front passenger seat. which was almost empty and full to the touch. There was also another 32-ounce bottle of Corona that was full to the touch and filled on the floorboard behind the front passenger seat where it is located. Standard field sobriety tests were conducted, 4 out of 6 HGN, 4 out of 8 walk and turn, and 1 out of 4 one-night stand. TIC was read and the defendant refused to provide a sample. A blood search warrant was then executed.
It's damn elementary, Mr. Rivas Diaz, that you're not to have alcohol in the car while you're driving. If it's proven at trial, it's a minimum of 6 days in jail, flat to any sentence that you get. I'm going to find that there's probable cause to go forward with your case. I am now issuing a restriction on your license. You are not allowed to drive any vehicle that's not equipped with an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond and put you in jail. Do you understand? You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. You're not allowed to drive unless you have valid liability insurance in your name as well. That is also a condition. You violate these conditions, I will put you in jail. There will be no more PR bonds for you. This is not a revolving door. Do you understand? Okay.
Mr. Leo does not have a valid driver's license. So we're asking for the no driving affidavit and yeah, for them.
This is an affidavit that you're going to sign with me, Mr. Rivas. If I find that you drive, I can have a contempt hearing every time you drive. It's a violation in and of itself, and I can throw your ass in with 180 days every single time. Do you understand? There's nothing in this life that you can justify getting into a car and driving. I will put you over my knee like a little child, and it's not gonna fare well for you. Do you understand? You act like a child, you will be treated like a child. So what was he driving then?
He was driving a vehicle, Your Honor, but he is present with his mom. Which I believe.
He's still gonna have to put an interlock on it because I don't trust that he's not gonna drive without it. You will also get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. You do, and I don't care what the excuse is. It's just not gonna go well for you. You understand? Okay, come on. Thank you. Yes, ma'am. Counsel, you ready? Yes.
He doesn't have another rating.
Oh, sorry. Let me blow through the arraignments first. I'm sorry.
You reset.
Well, who's your client?
John C. Garcia, he just needs a reset because some blood.
Yeah, I mean, oh, is there a bond violation?
No.
He doesn't have a judge. He doesn't have.
Ramona, top of page 8, what is it? PCOT? Oh, he's supposed to take a test today?
Yeah.
Okay, he's got to take a test though.
Oh,
So we'll send him. Is he here?
yes.
Great, we'll send him. We'll give you, pick a date, we'll give you a reset, and then I guess we'll reach out to you if he tests positive or
Okay.
whatnot. Yeah, okay. If you don't mind, just leave your cell phone with Ramona so we had it just in case, please, because it's very hard to get a hold of you guys. Okay, come on. Good morning, sir.
Good morning, Judge.
All right, you are Mr. Rivera. Sir, you're charged with assault of a family member. You're facing up to a year in jail and a $4,000.
Judge is charged with a receiving a whole brief.
Oh, I'm sorry. I got 2 Riveras. Sorry. Omar, sorry. Okay, you're charged with, my fault. You're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir. Okay.
May 31st, 2026, officer observed a vehicle going 84 in a 65-mile-per-hour zone. Traffic stop was conducted. Officer detected a strong odor of marijuana emanating from inside the vehicle. The officer located a glass jar in the back seat. containing 1.5 milligrams of, or 1.5 grams of marijuana. The defendant advised he had a firearm in the car, and the officer located the firearm under the driver's seat on a holster.
Okay, does he have a license to drive?
He does, and he filed.
Okay. All right, Mr. Rivera, I'm going to find that there's probable cause to go forward with your case. While this case is open, you are not allowed to be in possession of any weapons. Do you understand?
Yes,
As long as you can comply with these conditions, all will be well. Do not pick up any new cases.
sir.
For now, we will have you sign a reset. After that, you guys will be free to go.
Thank you, Judge.
Please, guys. Oh, wait, hold on. We need him to stay to sign conditions. I'm sorry, I forgot about this. So what I'm going to have you sign a reset. I'm going to have you take a seat while we get bond conditions. Once you sign, at that point, you'll be free to go.
Sure.
Please.
Thank you, Judge.
Sure. No weapons, no driving without insurance as well.
No driving
Please.
insurance.
Yeah. Or you were Mr. Madison.
Yes, sir.
Sir, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay?
October 5th, 2025, officer dispatched to, Inwood Hollow Lane. Complainant stated that the defendant had struck her with a closed fist, causing pain. Complainant stated she retrieved a stun gun and used it in an offensive manner.
Stop. You have the right to remain silent. Exercise that right. Mr. Madison. So we have two complaining witnesses in this case.
Yeah, so it looks like, to provide a little more detail, complainant stated she was at home with her friend, and, it looks like the defendant is her friend's, boyfriend. And, after that, it says that, I believe both the complaining witness as well as, the friend, had gotten into an argument, and, when she went back outside, the defendant had assaulted the friend, who declined to provide a statement.
Okay.
And that's when the defendant had struck the complaining witness with a closed fist after that.
Mr. Madison, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to have any contact with the complaining witness in this case, not to go back to where this house is, not to be in possession of any weapons. Either of the complaining witnesses, you're not to have any contact with them. If you violate these conditions, I will put you in jail. No more PR bonds for you. Do you understand?
Yes.
Okay. We are going to reset your case to give you time to hire a lawyer. So I will have you go to Ramon and sign a reset. After that, I'm going to have you take a seat while we get your bond conditions. At that time, we'll reset your case to give you time. Come on.
So no contact with complainant and then no rights, right?
No going back to the house either.
Yeah.
Either complaining witnesses.
Oh.
Both, please.
Dan?
Morning, Ms. Sims.
Mr. Goins. Can you have?
Mr. Sims, Ms. Sims, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
April 16, 2026, officer was dispatched regarding a female asleep by a gas pump. The officer reviewed security footage and observed the defendant operating a motor vehicle in a parking lot and driving away from the gas pump and striking the vehicle. The vehicle then continued on to Lake Houston Parkway against the flow of traffic and struck a truck head on. Both complaining witnesses identified the defendant as the driver of the vehicle. Complaining witness 2, driver of the vehicle that was struck head on, was transported to the hospital. The defendant appeared unsteady on her feet and swayed while standing. Officer detected a strong odor of alcoholic beverage from her person as well as glossy eyes. The defendant was disoriented and did not remember how she arrived at the scene. The defendant states he consumed 5 beers at Chili's in a local bar and once each year month was go to bed. The defendant was checked by EMS but declined to transfer to a hospital. Standard field sobriety includes HDN, but she could not perform walk and turn or one leg stand due to a laceration on the bottom of her foot. And the defendant provided a blood sample.
Ms. Sims, you are on bond for this case. You failed to appear. You've picked up a felony case and they gave you yet another PR bond. No, ma'am. Take a seat from in the jury box. Can you appoint a lawyer, please? Oh,
Number 20, Judge Robles.
it's the last one.
Yes.
Hey Judge, how are you?
Hey, good morning.
How's it going?
Good. Look,
Yep. We're getting it right.
all conditions will continue. You violate again, I'm going to triple, quadruple, maybe quintuple the bond next time. Your bond is at 15,002. If I have to quintuple it, do you understand me? You will come every Monday, every Thursday for testing. All conditions will continue as they were before.
Judge, what I was gonna ask, he hasn't been positive for anything in over a month. Can we do weekly testing? He is coming up twice a week.
I have a lot of history with Mr. Robles, and we have a lot of bond violations. We have a lot of bond revocations. No, sir, they will continue. You don't get rewarded for continuing violating conditions. They'll continue for the foreseeable future, and we'll go from there. Trust is so very easy to break and extremely difficult to gain, especially when you start garnering laundry lists of criminal cases. Do you understand? I will protect my community at all costs. I don't care if I have to keep throwing your ass in jail. It is what it is. You hold the keys to that cell. No one else. Okay?
Thank you, Judge.
Thanks.
Number 2, Judge Argues. Argues.
Yeah. Mr. Garcia has, went further this morning and took AUA. Is that the service for testing for him?
Veronica. Okay.
Yes, as you raised it, negative.
Okay. So we'll give you a normal reset. He's still subject to the random testing. He's going to get tested. Just let him know. Don't use. Okay. Okay. Thank you, Mr. Goin. All right. You are Mr. Arzu.
Yes.
Sir, you're charged with the interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
April 28th, 2026, in Harris County, Texas, around 1:30 a.m., the officer observed a motor vehicle with expired registration and initiated a traffic stop. The driver, defendant, admitted to not having a Texas driver's license or financial responsibility, and a check on defendant observed he had an open warrant. The officer requested the defendant to exit the motor vehicle, who ignored the request, looked down on his phone, and began scrolling. The officer waited a few seconds before opening the defendant's door for him to exit. The defendant grabbed the door, pulling it away from the officer, who requested 3 times for the defendant to exit, which he ignored. The defendant reached toward the bottom of the seat with both hands and was immediately told to put his hands up on the steering wheel an additional 3 times, and he ignored this. The officer drew the firearm and the defendant eventually slowly exited the vehicle and was detained.
Okay, Mr. Arzu, I'm going to find that there's probable cause to go forward with your case. Does he have a license to drive?
It says it's eligible on the screen. Let me just double check to make sure it's still eligible.
The only condition I'm placing on you, Mr. Arzu, is if you're going to drive, you must have a valid Texas driver license. You must have liability insurance in your name. Those are the only conditions, and I'm just asking you to follow the law. I'm not asking you to split the item. Do you understand? Really, just if you're going to drive, just have a license, have insurance in your name. That's it. We're going to reset your case, give you time to hire a lawyer. So I will have you go to Ramona, sign a reset. I'm going to have you take a seat while we get the bond conditions. Once you sign them, at that point, you'll be free to go. Okay? Please, sir.
Sorry, it's still up.
That's okay.
It's showing he's eligible, what did you want his, bond conditions to be? I'm sorry.
No driving with a license and insurance. That's it.
Oh, no driving without a license and insurance. Thank you.
Hi, bud. What are you?
Mr. Kiwanis Carey, you think that the new case, I'd like the court to hear probable cause on it. And
Okay.
What was the last name? I'm sorry.
Harry with a C.
Oh, you're the CEO. Thank you.
C-A-R-Y.
Arzu,
Okay. June 5th, 2026, officer was dispatched to an assault in progress / unknown weapon check, at a Harris County, Texas apartment complex. The call supervised the defendant was hitting a woman and was in the bathroom of that location. The officer knocked on the door and a female opened the door and was crying, advising that the defendant was in the bathroom. The female stated that her and the defendant had only had a verbal altercation. The officer observed no physical injury on the complaining witness. The officer told the defendant to come out of the bathroom and show him his hands. The officer unfolded with his taser and pointed it at the bathroom door. The defendant attempted to run past the officer, and the officer attempted to detain the defendant. The defendant continued to pull away from the officer and placed both arms under his chest. The officer eventually got control of the defendant with the assistance of another officer and handcuffed the defendant.
East,
So they didn't believe the assault occurred. So I guess that's why they didn't file it.
Yeah, I don't see another assault with it. I believe because, she had denied there being one or no.
No answer is okay. Kobe, what's up?
A few things.
Sure.
Even accepting is true, the idea that he tried to run past them, which is absolutely not true, because I watched all the body cams this morning. He's taken down in about 8 seconds. He comes out of the bathroom doing this. What's not mentioned there, one officer does point a taser at him. There's another officer with an actual gun pointed at him. The big discussion these officers have is about the use of force report they're about to have to write, because they both pointed guns at a guy who they probably don't even have reasonable suspicion at that point. But the big issue here, taken down to the ground, slammed to the ground, handcuffed, gun pointed at you, taser pointed at you, is an arrest. This isn't a, hey, we need to detain you for a while and talk to you about what happened here, reasonable suspicion detention. This is, I've got probable cause to slam you on the ground and bust your lip at gunpoint and arrest you. They don't have probable cause for an arrest at that time. Not only does she say, we were just arguing, as the DEM says, they do no visible injuries. That's why the DA's office doesn't accept the assault found number charge clearly in this case. So if they don't have probable cause to arrest him, then he's not, even assuming he's interfering, which he wasn't, he's not interfering with any official authorized duty of the officer because there was no PC for arresting him. The other problem here is his house. They're in his house arresting him without a warrant, without consent to go in. The court should know. The lady comes out and is trying to tell the officers don't go in there. They actually put hands on her and push her aside and say, be quiet and go over there. They go into this home, break the threshold without a warrant. So they don't even have the authority to arrest him anyway without a warrant. There's no exigent circumstances because this lady has said at this point nothing happened. They don't see
Well,
it.
the exigency is when they get there.
Well, and then that's
Right.
dispelled by her appearance. Because when they get there, they're there for the idea that she's been assaulted. They see her, they see no marks. She tells
But she's
them,
still crying. She's
Sure.
disheveled. So that is right there, reasonable suspicion, just to even begin an investigation.
I agree that they would have
Right?
reasonable suspicion to investigate.
Sure.
However, this goes beyond the detention. One, and we look at the factors that distinguish an arrest from a detention. A force is used. And in this case, not only is force used pointing two weapons at the guy, but he's also slammed to the ground. He's handcuffed immediately. There's no come out with your hands up. That's not a detention. I'm just investigating. That's a I'm putting guns at you, get down on the ground, you're handcuffed, you're slammed down. This is an arrest. And they don't have probable cause at that point to arrest.
Is it the same complaining witnesses in the terroristic threat? And do we have a no contact order?
The terroristic threat is an old man Uber driver who gets into a screaming match with my client.
Okay.
It's totally different.
What do you think?
I can verify it's a different complaining witness.
Well, no, not about that, about whether
Yes,
there's PC to go forward.
I do believe that, while, they had not observed visible injuries on the complaining witness. I do believe that they were just trying to temporarily detain him for an investigation, and based off of what I have in the DIMS, just him attempting to run past him
The
and not.
problem is you're going way past by getting into the video, and I haven't given them an opportunity to like,
Even if you don't get into the video, the fact that it's in the DIMS that we pointed a taser at him, pointed a weapon at him. It's in the DIMS that we took him down to the ground and handcuffed him.
well, here they take him down, right? And then he gets up and then he still tries to bolt. He's still trying to, or not bolt necessarily, but trying to, get off me. Just get off me. Let me.
I think the question is at the inception of when that happens, is this an arrest? Is that what's going on? The other thing that's in the DIMS that wasn't read, and I don't probably didn't think it was important, but it would be for the purposes of whether these officers are arresting him or detaining him. They say we conduct a full search on him. You search people instant to arrest. That's when you get to go in their pockets. You may get to Terry frisk. A
Well, I didn't even think we even got that far.
But it's in the.
Sure.
And the idea is that if you're searching someone, that's because you've arrested them. You can Terry frisk a person who's being detained, but a full systematic search, which is what it says.
But you're going past. First, let's get to where, so we have reasonable suspicion to begin an investigation to see, hey, can we investigate to see, did an assault actually occur? Did something else occur? He tries to get out, and according to the DIMS, he's trying to run. They take him down, comes back up. He's still, at that point, they can detain him, right? Just to see what's going on.
I don't think
Yay or
it
nay?
says that he gets up from the takedown and tries to run. I don't think that's what it says.
What do you
I think it's that
say?
he was trying to run past them and they took him down. Again, if we believe the lie report, which we're talking about,
Touche.
because that is absolutely not what happens. And I think everybody should just be very clear about this. Whether the court has a duty just to stick to this piece of paper or not.
So why don't we do this? Why don't we set up for a full formal PC hearing tomorrow? Get the video. That way I have to give them time to look at it.
Okay.
Can we set up for tomorrow? Take a look at the video. Let's see if it actually occurred. And then I will take a look at the video as long as I give them the opportunity
No,
to
that's
say
fair.
it. So
I understand that. Yeah, I get it.
I'm happy to do it.
Sure.
We'll do a full blown, take a look at it tonight.
Okay.
Let's do it tomorrow. And then you can bring up the video and I'll take a look at it.
Good. That sounds good.
We'll go from there.
Okay, thank
Yeah.
you.
Okay. Yeah, just ask Wilma to roll tomorrow. We'll do
We'll
it.
do it.
Hey, okay, come on.
It's for Mr. Malik Latte, Judge. He's in the jury box. He had a BDR for missing a drug test. He just tested it came back positive for THC.
It's a second BVR too. What are we doing with this case? It's an old case. I'm not down with repeated bond violations. I mean,
Trust me, Jack, I know.
yeah, so,
Spoke to the state about it. It's an assault case with a lot of back and forth between the defendant and the complainant. He has no criminal history. He's a young kid. The state is willing to consider PTI with mitigation package. I also did speak to my client about the bond violations, first of all, why he missed the drug test. He used the back end or something that word. I told him he needs to at least call and but also the positive test too was, he says he has been using CBD gummies.
he's not allowed to do anything.
I did.
Oh, Delate, come up.
Iterate that change. But he is PTI eligible. He does need to give us some mitigation package.
I'm putting him in jail.
We have 2 research just to get back.
Yeah, you can have 2 weeks, but I'm putting him in. He's not getting it. You're not allowed to use. I've told you not to use. You're on bond for a misdemeanor case. You have bond conditions. There's no one that can allow you to use. I already gave you 1 and I can't continue because if I do, then I'm telling you it's okay for you to continue to violate bond conditions when it's not. Do you understand?
Yeah.
You will go to jail today. I'm sorry. Okay.
Well,
Good morning, Mr. Murray. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 31st, 2026, in Harris County, Texas, officer observed a vehicle on Gray Street driving the wrong way. A traffic stop was conducted and defendant advised he was coming from a party. Officer observed glassy, watery eyes with alcohol emitting from the vehicle and defendant's person. Defendant advised he had consumed 2 beers. Danger field sobriety tests were conducted. 6 out of 6 HGN, 1 out of 8 walking turn, and 4 out of 4 one-line stand. The IC was read and defendant provided a breath sample. Results were 0.127 and 0.116.
Any prior DWIs? Does he have a license?
No prior DWIs, Your Honor, and his license is eligible.
Okay. Mr. Murray, I'm going to find that there's probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication. You will be randomly tested. Do not use. I don't care that it's just marijuana. It's not. It's no, don't use anything illegal, including marijuana. Do you understand? You will be tested. If you test positive for alcohol or anything illegal, I will revoke your bond, put you in jail. No more PR bonds for you. You're not allowed to drive unless you have a valid Texas driver license and liability insurance. You must maintain car insurance. As long as you have that, then you may continue to drive. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel, and he'll tell you if and when you have to come back to court. All right? For now, we'll have you sign a reset. You'll get with Veronica for your bond conditions, and then you're free to go.
Thank you.
Please. Hey,
Judge, may we approach?
please.
Mr. Olate?
Yep.
Sorry, I forgot to ask you about a bond for.
Yeah, I did. 5,001.
Oh.
Yeah.
All right.
Okay.
Thanks, Judge.
Yes, sir. Thanks.
All right, thank you. Yes.
Yeah, of course.
I have a question. You guys reached out on this, number for Joseph Tolau,
What's it? What is it?
2610063. He's currently assigned to report on the DWI second.
Okay.
And his case is reset for June 25th for disposition setting. Ask one and if you'd like to include his misdemeanor case and, the U.S. was a party setting.
Yeah. Yeah, of course.
Thank you.
Everything. Hi, Enrique. Okay, just let me know when you're ready. What's your cost number?
It's 2621-799. 2621-800.
Yeah, I just need one. I'm sorry, 2621-799 on Chavez, right?
Correct.
Okay. Yeah, 2621-799. We're waiting on a translator, so, but it's, get ready. It's, Mr. Leonard, you ready?
Yes, sir. How you doing, Judge?
No, we're waiting on the translator. Hi.
A DV client. Last name Thompson. Thank you, Gary.
Mr. Tunson, come up. Do you really want to go to jail, sir?
No, sir, I do not.
Do you see how many people we put in jail?
Yes, sir.
It's either you have a problem with alcohol or you don't care about the bond conditions. You will now get a scram on your ankle. that will test for alcohol 24/7 7 days a week, 24 hours a day. At this, I have nothing left at my disposal after this other than jail. Do you understand?
Yes.
I don't give a rat's behind what your excuse is. If you ever test positive again, you will go to jail. No questions asked. Do you understand?
Yes, sir.
If you have a problem, now is the time for you to address it. Because if you don't, I will do it for you. We will not have this conversation again.
Yes, sir. I understand.
Okay, Mr. Lee.
Thank you very much, sir. I appreciate it.
You are Mr. Chavez Sante.
Yes.
You were charged with 2 cases. You were charged with driving while intoxicated and failure to stop and give it information.
Yes.
What? You were facing up to 6 months in jail on both of those cases. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Officers attached to a citizen holding defendant in a public parking lot. The complaining witness held down the defendant. The complaining witness sustained injuries to both her knees, which were straight, and waiting for the officer to arrive. The defendant was
Quiet down.
The officer observed the defendant's vehicle had damage to front left panel and observed gears on the passenger door forward. The officer opened the door to the vehicle, observed 6 empty cans of beer on passenger side of the vehicle, as well as a half-empty cold Modelo in the center console. I'm sorry, how many? 6. And there was 2 unopened beers in the back floor board. The defendant had bloodshot eyes, slurred speech, unstable balance, and heavy smell of alcohol coming from his breath/person. He had also urinated himself. The complaining witness stated he was in the parking lot when the defendant's vehicle backed out of a parking space and went nose to nose with the complaining witness' vehicle. The defendant drove forward and scraped the left side of complaining witness's car. He rolled down the window and the complaining witness smelled alcohol on the defendant. The complaining witness told the defendant to wait, but he had driven off. The complaining witness followed him, and when the defendant got out, he stumbled in a parking lot. He started to run on foot, and that's when the complaining witness caught up to him, and they fell to the ground. The defendant stated he's not feeling well, but they conducted HDM, which resulted being 6 out of 6. And he was unable to complete walk and turn, as well as one leg stand due to his head hurting. A blood warrant was executed at the hospital with a BAC of 0.141.
Does he have any prior DWIs and does he have a license?
He has no prior DWI. I don't have a driver's license attached. Let me see if it's on his report.
Judge, she was pretty beat, pretty bad by this citizen, had to be taken to the hospital, I thought it was 2 weeks. Had some severe head injury. Turns out the citizen was a HPD cop and went off on.
Mr. Chavez Sante, I'm going to find that there is sufficient probable cause to go forward with your case. I would guess that it's elementary that you're not to have alcohol in the car while you are driving. If it is proven in trial, it is a minimum of 6 days in jail. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will get a portable device that you're going to take with you everywhere you go to prove to me that you're not consuming alcohol. If you do, and I don't care what your excuse is, I will put you in jail. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they will very well might put a detainer on you and you will be stuck in custody for a long time. Do you understand? What did I just say?
And I don't think I'm going to.
Very good. I'm not asking much from you. I want you to follow the law. If you do not have a Texas driver's license and liability insurance, you are not allowed to drive. You will be signing a promise with me today that you're not going to drive. I don't care what you have to do in this life. Do not drive. Do not consume alcohol. Use your portable device. If you skip the tests on your portable device, you will go to jail. You understand? If you have any questions, talk to your lawyer. Your lawyer will help you out. But if I have to put you in jail, you will not get any more PR bombs. For now, we will have you sign all the documentation. Tell me about, he hasn't made bond or he has made bond?
No, we're asking you to grant the PR bond for cases.
Okay, I will grant you a PR bond today, but this is not a revolving door. You violate conditions, it's just not going to go well for you. We will have you sign all the paperwork, and after that, we'll release you to your lawyer. Okay, thanks, Enrique.
If you're ordering
A portable device, correct. He has a boatload of beers in the car, so
She didn't mention to you that there was a passenger.
for now, I want to make sure that there are no issues. Correct.
It's an extremely long.
I will pay for everything, but just tell him there's no excuse. Please advise him. Yeah, I'm both, correct.
May I reapproach?
Yes.
I just told my client, he has a vacation scheduled in like 2 weeks, like a week. And so, I need your permission to just put him on the random calling schedule.
Where is he going and for how long?
Unfortunately, he go to Las Vegas for like a week.
Tell him that he's going to get tested as soon as he gets back. I don't care where he's going. If he uses anything
So he understands.
on the day he gets back, he's getting tested. Let him know.
That's fine.
Okay?
So
Yeah.
he has your permission to go?
Yes, but not to use.
He knows
I
he
don't
gets
care.
tested when he gets back.
Right. To tell him the test for alcohol, go back.
Just-
All right. Okay. Hi.
How are you?
You look different.
A shade.
You look younger.
5 years.
Yeah. What's up?
I look bad.
No, I didn't say that. I just said
Cheap petite that is like,
kind of iffy, right? What's up?
what do you think, Judge?
Beautiful.
We're set for trial this week.
Great.
Do you know the order for tomorrow?
I don't. I have no idea. I know, but I'm set with me as well too. So I have no idea.
We're also setting Galveston as we speak since last Friday. I'm just letting the court know, but we're ready.
Okay. I mean,
So-
well, I don't know who's. Do you guys have any?
Got the same guy, so we're still ready. But we got the final.
The other, this case, is first? Okay.
What about?
Ready. We're ready on all three.
Okay. So we'll go on
So
one
what
of
I
them.
tell Mr. Thiessen.
Just be ready. Be ready.
Be ready. There's 3 cases set, and they seem most enthusiastic about ours or something.
I think yours is the oldest.
I don't know me either.
How? Let me take a look. Hold on. Let me see.
Your Honor, but we do have an assault plan on that.
Is anyone in custody?
No.
No.
Okay, I'll decide how I'm gonna send this text message. Think about it. Are we the oldest though?
I'm looking right now. Let me see.
Yeah, I believe is the oldest.
How do I get, there we go.
She could possibly be wrong.
No.
And of course, the system is down.
I can pull it up, Joe.
It's not working for me to pull up the trial docket list.
Pulling it up now, Judge.
Thanks.
So Mr. Barba is from June 2023. Mr. Orego is from September 2022. The assault case is from October 2022.
So it looks like you're up first. I'm not ready to reset you yet, just in case is yours a felony case in Galveston?
No, it's a misdemeanor that they need to get
So-
rid of. They're really slow in doing it.
Yeah, you're first up.
Okay.
Okay, so just be ready in the event something happens, because you never know. Right, you're up next, and then we'll just see.
Okay.
Did you want to say something?
I did.
Okay. Yeah, come on.
Okay, so I'm fine to be up, and I'm fine that we're on trial docket. I just announced ready for court 7, on the trial docket in the morning as well.
Okay,
You know, I mentioned that I had these 3 trial cases scheduled for tomorrow.
yeah, I didn't know that you had other trial cases. You didn't say it to us.
Did you talk about issue?
No, you said about federal court.
Right.
Something about federal court that you had not a trial setting, it was a,
The joint management conference?
correct, or something, but it wasn't a trial setting, and I didn't hear anything about a trial setting in court 7. But-
Oh, okay, I'm sorry, that was the.
If you go in court 7, then you go in court 7. I don't know, but just, I'm gonna see, if we go with them, then we'll just reset your case.
Okay,
So-
so what time should the defendant be here?
Judge, what is this on? Ortega?
Is it
Orego?
Orego? Just have him on standby, because I don't want him to come for nothing. Just have him on standby. You and I can meet like at 9:30 tomorrow, and we'll know for sure if ready to go.
Okay,
And then we can just call him down and then just have him like maybe half an hour, just be ready to come down.
okay,
That way, I don't want to waste his time for nothing, just to come down for, but if we do go, just have him ready.
okay.
Yeah.
Okay.
Okay?
All right, that is.
Yeah.
That's all.
Yes, ma'am. Of course. Hi. Hey, good morning. So on Alvarado, we're trying to keep the dockets on Thursday as skinny as possible because of FIFA.
Right.
So we're just gonna move it to Friday for him to test.
I have Grace Sims, today,
Okay.
You need to talk to her about the health issues and that, okay?
Well, whether I was gonna give her another PR bond. Because the problem is gets a general order bond at EWI, fails to appear. Then she picks up a felony case and then they give her yet another PR bond. I mean, come up, Miss Sims. This is not a revolving door. It's not a revolving door. You don't get to continue to pick up criminal cases and get PR bond after PR bond. Do you understand? I'm just, I'm hard pressed to give her yet another PR bond.
I was saying, Judge, like I said, she's got this recent charge. She told me that she's been running the A classes at her church. And I've actually been on her pretty strictly. So to send me some proof of that, but I think she's pretty scared of her. I don't think you'll regret giving another peer, speak for herself.
So this is what we're going to do. Does she have a license to drive? And then,
I want to hear, I'm gonna check this out.
I guess, can you run an NCIC? Does she have any other prior criminal history? Does she have any other DWIs?
Yeah, let me check it out. Her driver's license is showing not eligible. I'm gonna do a TCIC check right now.
Ms. Sims, there's no quicker way to go to jail than to drive without a license in this court. If you do not have a license and insurance in your name, do not drive. There's nothing in this short life that we have that you can justify getting into a car and driving. If you do, I can have a contempt hearing because you will sign an affidavit promising me that you're not going to drive. If you do, every time you drive, it's an offense in and of itself, punishable by 180 days in jail and a $500 fine. Do you understand? I don't care. You will come here once a week randomly to provide a drug test so we know that you're not using. You are not to consume alcohol or illegal drugs. And you will come here once a week randomly to test so we know that you're not using. If you do, you will go to jail. And I'm telling you, you will not get a third PR bond. Do you understand? If you have a problem, you better do whatever you can to address it. Because if not, I'm going to do it for you.
I'm not showing any of the criminal history.
Veronica, you heard all that, right? Okay. All right. You and only you hold the keys to that cell. I don't know who you have in this life, but if I make your bond $10,000 and you don't have anyone to pony up that money, you'll be stuck like Chuck. Do you understand? Okay. All right.
I think you for Alvarado, the basically directed
To just Friday for this week because of FIFA.
Did you want to do all the Thursdays?
No. Just this week because of FIFA. That's it. He has a test on Thursday here. Move it, if you don't mind, to Friday because we're trying to kill everything on Thursday because of FIFA.
Oh, just Alvarado? Or
Just Alvarado.
Okay.
Or do we have anyone else?
Oh, you said Rosas.
Okay, so yeah, on Friday as well. Yeah. Thanks.
Another.
Shoot.
Mark us a flight Friday morning, so that gives him 2 full days if we can do them all.
You okay?
I'm just,
No problem.
he asked me to make the court aware. I've now made the court aware.
Okay,
That's it. Okay.
we got it. We got you.
See you.
Hey,
Yes,
the problem lies,
yes,
some of us have the gift of gab, if you know what I mean. So
I do know.
kind of, if you abridged version for all of us, then we can streamline, you know?
I am not a long-winded person. I'm not, particularly in trial. I get in and I get out. I just don't think the state's typically used to having experts like we have come testify in the cases.
What do you mean?
Well, typically it's like, oh, I have a couple witnesses and I'll be done. It's like, well, the defense can have a case too. You know what I mean? Which is
Yeah,
more
that's
common
what
than
it
it's
is.
off manslaughter or something. It's a whole another case.
Sure, of course, but this is not a capital DWI, is it?
I don't know how Mark's treating it.
I don't know.
I speak for me. I'm quicker.
How many witnesses do you have on there?
Double checking right now, but
Sean's.
Okay.
Oh, there he is.
I don't want to talk to him. He's too put together.
That's who you're trying it against.
Also, it's normally fast. So, I mean, this is like a great club.
Sean, you ready?
Yes, Judge.
Yeah, how many witnesses you got tomorrow?
4.
Okay,
Yes.
so,
I was asked to alert the court, and he basically said if we can't get it done by Friday, we need continuance. But what I'm hearing from the court is you expect to be done by Friday. We're going to take 20.
hopefully,
If not, then I guess you can roll it till next week. I don't know, it's up to you.
we'll see.
Okay,
Okay,
all right, thank you.
you ready? Yes, ma'am.
It's the case. Fine. I need very fast, Judge.
Okay, who you got?
I think it's very, very, we, pre-sign waiver and the order.
Okay, you want this?
Am I right?
Have you shown it to them so they know why they're,
I did talk to them about Judge, but I will talk to them after.
well, here, I'm going to show this to you, so. This. Yeah, of course. So when they sign it, when they get on either probation or parole, that's what they're signing there. So they know now while we're entering this, so they don't have the ability to get, I can't give them a bond because they've already waived by virtue of signing the agreement. Okay,
Thank you, Judge.
thanks, guys. Mr. Tyson.
Good morning, Your Honor. I'm here on Andy Jones, and here for Daniel Henry. Mr. Jones was made bond, and
Yes.
I believe the case was settled for a plea. She indicated to me that she does not engage in fight case.
Yes, and that's okay, but we're putting conditions on her.
I
So,
believe she's already signed bond conditions, and she has a need to monitor and
great.
all of that stuff.
So, hey, I'd like to do random testing once a week, please.
Me?
Not you,
Oh,
her.
no, here, I know.
Okay, cool. Just leave that in. Okay.
And from what I can't say, she wants to resolve this sooner than later. But
Whatever she wants.
I don't know Mr. Henry's calendar. So if we could just, I guess, set it out for a while and I'll.
Let me see. I don't know how old it is. Let me see. I mean, I think they're really, really, really new.
It's
Oh,
like this is.
Yeah, that's not, all the cases happened within a week. If I remember,
Looks like your Tennessee girls from May 19th, and then you'll try to apply for May 20th.
oh, it's like brand. Okay.
no, yeah, it's like brand new. It's just, she just picked up 3 cases in rapid succession, all within like a week.
Okay.
So
All right, so I'll, get a reset and,
whatever you want.
okay.
Yeah.
All right.
Okay.
Thank you.
Yes, sir.
Okay, I'm just trying to figure out what's going on right now. Are you revoking the bond?
I'm revoking his bond. I'm not going to hold him in contempt. I'm going to revoke his bond.
Okay, can we set a bond?
Yeah.
That's just, I mean, side, so.
And I'm going to double all of them except for the felony case. But so now 50,006, please, on all of his cases. And then, but talk with him this week. We need to decide whether he wants to set him for trial or whether he wants to accept it. But
I think he's just frustrated because when we were on here on Friday, it seemed to be about the something Clark knows about the hearings. And now that we're here, all that is just being thrown out into the. You
I
don't
was-
care about something.
no, it's just way too much drama. And I'm just ready to put it to bed. It's just going to continue. It's every week we have a new bond violation. If it's this, if it's that, let's just be done with it once and for all. The theft is 250 day, or one of the cases is 250. It's time. So,
We'll talk to the state.
also the only other thing I would say is, do you know who the felony lawyer is?
No,
So maybe,
I mean, he's not pleading on the felony, you know that.
okay, so we'll just do, I don't know if there was a global resolution
There
that's,
probably is, but he's not. I
But-
mean, the multiple times I've talked to him, he's not taking their TDC off.
oh, they offered him TDC up there.
It's just, it's not gonna be typical.
I
Right.
know that.
Okay.
All
All right.
I will go to the state.
He will, unless he bonds out, he'll auto-populate today. But regardless, this week we need to know because either he accepts it this week or we set it for trial. And Friday's the last day. So, okay. Thanks, Alyssa. Hi, please.
I Mr. Smith, Lewis, sir. You got it. He's on bond.
You say Lewis?
He's either under last name Smith or Lewis. Last two last names.
It's under Smith, it's Derek.
Yeah.
It's under.
Oh, the new guy.
Yes.
Okay.
Judge, we were going over his bond.
Thank you.
Judge, we were going over his bond conditions. He's been having an ankle monitor since about February. This year, no bond violations. We're asking at this time if it could possibly be removed. We would like to request no threatening or harassing contact with the CW. Again, he's had no contact with her despite having a 6-month-old with her.
Have they spoken with her recently?
The state has not, but Victim Service VAC has spoken to her. She said she wanted to
So-
up, and she said she wanted him to have contact with the baby.
Let's do this. Let's have them reach out to her. Do a rip. Save it for maybe tomorrow, the next day.
Okay, yeah, I can come back.
I'll waive it.
Waive the signature on the bond conditions?
No. Well, that, yes, but I'll
Okay.
waive his appearance.
Okay, understood.
Get the rip done. She okay with it? Has he been attempting contact with her now? Have they had contact? Is he violating conditions? And go from there. If he has not violated bond condition, if he's been fine, there have been no issues, then I'll acquiesce, but I want to hear it from her.
I understand, Judge.
Yeah.
Okay, thank you, Judge.
Yes, ma'am. Yes, ma'am.
I just wanted to introduce myself. I'm Spotman, or Harrison County for the.
Yes, of course.
This will be my assigned court from now on.
Oh,
It'll
great.
be
Welcome.
Capacity switching, week.
So which one are you? Is it mental health? No.
No, Judge, I'm misdemeanors.
Okay, so you're just going to be taking all the PDO cases?
Yeah.
Okay, well, welcome.
So it'll be capacity, elite, me, we're gonna just switch, but they're
Okay.
our assigned, this is our assigned court for.
Great. Well, thanks.
And so,
Okay.
future, whenever.
Yeah.
All right,
Okay.
thanks, guys.
Yes, ma'am. Thanks. You were Miss Rodriguez. Yes or no? Miss Rodriguez, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 30 days in jail with credit for the 7 days that you've done. You were giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. This will end up as a conviction on your record. You're from now on facing at least 30 days in jail from now on. Do you understand?
Yes.
How do you plead to this offense, guilty or not guilty?
Yeah.
Okay, ma'am, I'm going to find you guilty. I'll follow the agreement, sentence you to it. Good luck to you, ma'am.
You too, sir.
Okay, take care.
Turn around, please. All
Thank you. Yes,
right, thank you.
have fun.
He's all.
Hey.
When you have access to a court reporter, I would like to put your most recent application on record.
She's working now.
Okay,
I mean, I have one tomorrow.
okay, I'll just come back tomorrow, we'll put it on record tomorrow.
Okay. Hey. Hey.
I am supposed to run Emmanuel, yes.
Okay.
So criminal trespass, the complainant, a representative, she did on first charges, and that he had been living there for 3 years, so within a 2-week period, he getting there off and on. And, you know, that he had belongings there. I'm confounded as to how he was charged with trespass, you know, at a proper, you know, at a house that he lived at with children live.
Well, if it's someone else's house, right? Unless he's on a lease or unless he has a legal right to be there, right? Like you're on a lease, you own it, you know, you're renting it. and you can prove it, right? Someone else can exclude you from it. If whoever the rightful person is, right?
With the civil process. She's established immunity. If she doesn't dispute that. She acknowledges.
What are you looking for?
Oh,
What would you
I just
like?
said, well, we're gonna, I just need to reset.
But it's old. I think, we did a reset to figure out,
They're offering the PTI,
Well, what are the terms to that?
anger management. And the decision.
so if he does an anger management in a decision-making class, they'll dismiss this case.
No.
The thing is that it's old. So Riascos, come up. We set cases for trial at 180 days. Your case is 190 days, and it's time to figure out what you want to do with this case. You either need to accept the plea bargain agreement, or we are going to set your case for trial. They have offered you a pretrial diversion program that if you complete 2 classes, the case will get dismissed. You need to accept it or reject it today. If you do, we're going to give you a week to get everything done. If you get the 2 classes done, they'll dismiss this case. You understand? Great. I need you guys to talk to see whether if that's something that you want to do. If not, then we will go ahead and set your case for trial. But understand that I have enough drama in my life, Mr. Riascos. I just really don't need any more. If you want to set it for trial, we can, but I will not accept any more plea bargain agreements after that time. Do you understand? Okay, you guys tell me what you want to do. If you want to accept the diversion, just let us know, and then we'll give you some time to complete it, and we'll go from there.
If she could inform me to speak with her, it's not present. So-
She's right there.
Oh,
Yeah.
I'll read it.
Okay, please, Mr. Riascos. Alyssa. Hey, Farmer. Who's this?
Sorry.
What was the last name?
It's on.
Oh, we did something with this dude.
On page 14, Judge.
Yeah.
What did you do with him?
Oh, no, we didn't. No, we didn't.
So, Judge, go ahead.
Do you have a lawyer today, sir?
I do not. I don't have the funds for that. I've been going through a lot and
We're-
I've been staying away from my cousin and
None of that matters.
sure.
If you want a court-appointed lawyer, you have to qualify. Just because you don't want to go hire a lawyer, because you want to go to spend the money, because you don't want to go take the time to look. Hold on. Your case is 70 days old. Have you looked for a lawyer at all? How many lawyers have you spoken to?
I've spoken to 2 that I
Okay.
trust, but it's just.
Hold on. You may need to speak to 22 lawyers out there, maybe 30 lawyers out there. There are a gazillion lawyers in Harris County. 99 of them will put you on a payment plan. If you ask for a down payment, a couple $100 a month, they'll represent you. If you go to a Ferrari dealership, then expect a Ferrari price. If you go to a BMW, it's like finding a shoe. If you can afford Payless, you go to Payless. If you can afford Foot Locker, where the damn Air Jordans are $350, then that's what you do. You understand? But 2 may be insufficient to really get a good understanding of what is out there. Are you working at this time?
Yes,
Listen,
just for that, yeah.
okay. I don't want you to say something about the case because you have the right to remain silent. Anything you say, especially regarding the case, they're going to use it against you to prove guilt. So how much money do you make a month?
Not enough, maybe like around less than, it's just like I'm struggling right now, but I'm like $2 grand and it's maybe, I'm not really making much right now because I can't even, I was door dashing, but then the charge came up and within the background check. And, I've been trying to find something more more of like a long-term solution, because I mean, I'm not trying to do that for the rest of my life.
So what were you doing before this charge?
I was looking like in warehouse, it was just like manual labor, you know, nothing too complicated. I've worked nothing but warehouses, and I'm just trying to find,
Why did you stop working in the warehouse?
well, I couldn't go to work for the 2 days. And I, you know, I was through an agency, so there wasn't a lot of like, you know, wiggle room there.
Did you get fired? Did they
Yeah,
stop?
they will let me go, unfortunately.
Okay.
But,
Deputy, as you go in, we'll give you an application. I need to know everything about you, what kind of car you have, how many cars, how much money you make a month. Hey, tell him not to come in shorts again. Really. I mean, you're at a courthouse, dude.
So I would never put the shorts again.
Understood, Your Honor.
The dude's looking like he's going to a concert or something, for real. You're in a courthouse. Not in Toyota Center. Deputy will give you an application, fill it out, and then I'll take a look and see whether you, okay? Please. Park.
See, everybody's jump at the scene.
You want to go through the list? Oh, I thought I signed it. Maybe not.
He has two cases, one of them got signed, but the other one didn't.
Oh, sorry. Okay, I'll send it right now.
Davis on page signature.
2501.
Page 16.
2501. Bottom of,
Rivera, at the bottom of page 19.
2501.
That's it, Judge.
Do you have any other open cases? Are we done? Okay, I think we're done. Oh, who got, or no, you just appoint, you can appoint them, Warren. Who? It's okay. Okay. Who? Yes. Hi.
This is our intern.
Wow, nice. We got an intern. Welcome.
Thank you.
Are you a 1L, 2L?
Finish my second year.
Nice. It's, where do you go to school? Tulane? Nice.
No.
In Nolland.
No.
Nice. How's it going over there?
I like it. I like it.
You don't want to, is it prosecutor's office there too? No?
Yeah, but it's kind of, I want to be like a bigger system.
Mm.
Right here in school.
Yeah, it's great. No, it's a great place. You'll get a lot of experience here, especially, well, I know what, well, trials maybe, you know? Tomorrow for sure.
Okay.
Oh, speaking of which. Yeah. Well, good luck. Yeah, you'll learn a lot. Just hang tight and just stay here. It's awesome. It's great. Hey.
Good morning, Alan. How are you?
What's up?
Good. I have she had a haul on the docket this morning,
Okay.
and we're just waiting on mental health to come. So she, filed a bond fund violation. She didn't show proof of, attending.
Correct.
Harrison,
And she didn't show up here.
and the fact that she didn't show up here. She thought she, provided the proof of the Harrison. And I've been working with mental health since the last setting.
Did she go?
Forget.
Did she get it
tells me
done?
She went. She tells me she went.
Until I know with proof in my hand, I'm not reinstating.
I understand. I'm waiting on mental health to get here so they can
Okay.
tell me if they got it.
Yeah, just let me know.
11,000 should be.
Thank you.
Yeah.
I just have one case study.
Yeah, for sure. What's your cause number?
Cause number 257851.
257581. That's not a
Number 257851.
7.
It should be for an Andrea Edwards.
No, hold on. Maybe I didn't write. 257.
851. 0.
There we go.
Okay. So, this stuffing is going to Miss Edwards, positive thing, starting positive, all UAs for the 3 that she has so far have been negative. And she currently enrolled in IOP for IOP SOP March 11th. But she did admit on, what was this? Cinco de Mayo. She admitted she was drinking.
So we need to put a scram on it then.
Scram?
Yeah.
Okay. So the CSO was recommending bringing to your attention for supervisor admonishment.
Okay, do that, but she need a scram because we just can't trust her to, yeah.
Okay, so
Yeah.
you're making sure you don't need to
Yep.
amend the
Put-
conditions for scram?
Well, let's have her come in
Ever come in?
and then we'll, yeah.
So you want to report admonishment?
Mhm.
Okay,
And then, just remind me and then, well, I'm gonna put a scram.
okay, because right now she has, the ignition interlock with Smart Start.
Yeah, so that way, all she does is she blows and she probably doesn't have a blow schedule, so we won't know if she's ever consuming. Like now, the only way you know is because of the admission, so.
Yeah, well, with, CSO did confirm with Smart Start that it was on April 15th and on Cinco de Mayo. It was consistent with alcohol consumption, and the client was stating her boss had passed away, I think April 24th, and then she admitted to drinking on Cinco de
Yeah,
Mayo.
so yeah, I think we need to put a scram on her.
Okay, I'll leave the notes and I'll, set up for the court admonishment, which until written.
Yeah.
So that would be that.
Thanks. I'm gonna bend it. Once we get the deck down, bring.
Let me take it.
Will not raise your hand. This one, the primary information on the affidavit is true, correct? Thank you. She said, this is what
Alyssa, are the bailiffs back there?
I'm sorry?
Are the bailiffs back there?
No. Do I need to stay there until bailiff comes back?
I'm gonna bring them out now.
Okay,
We're
yeah.
done.
I don't think.
What do you need for that, David?
You can bring them out? Thanks. I hope that this has been an absolutely miserable experience for you. One of the worst experiences of your life. I want it to be. It needs to be. Because at some point, it's time for you to grow up and see that we mean business. And the criminal cases, the bond violations, everything in general, it's an effort to try to get you to see the light that at some point you got to grow up. It just can't continue.
Yeah.
You need to find it within yourself to see why things happen as they are. You know, there are a lot of people that blame this, they blame that, they blame cops, they blame complaining witnesses, they blame. But at the time when, if criminal cases continue to be hit, if you continue to pick them up, then it might be time to do searching within yourself, not just placing blame everywhere else. You know, Alyssa told me something that was very interesting. She goes, you know, when you come here, when you're with us, you act a certain way. And Alyssa was telling me now that when you're with her, you act a different way. But what you need to understand is perception is reality. You know what that means? If people perceive you a certain way, they will treat you a certain way. Dress how you want to be addressed. If you want to be addressed like a professional, if you want people to treat you with respect as the great person that you should be, dress how you want to be addressed. Act and talk how you want people to treat you. So when you come in here claiming this is bullshit, how are we supposed to treat that? How are we supposed to act? Considering all this and that, does it make us happy? No. I'm trying to get you to learn something. And I'm hoping the more of a miserable experience that this is, when you're out there in the free world, you will think twice. Well, shit, if I do this, maybe something's going to happen. If I say this, if I elicit this type of reaction from someone, it may end up in a bad situation. This is why we do what we do. It doesn't come from hate. It doesn't come from, no. It's time to stop and grow up. I'm not going to take you into custody now, Mr. Watson. But it's time to put these babies to bed. You understand? It's just entirely way too much drama. And I don't know what's going to happen with this. I don't know what's going to happen with this in general, but as I'm up to here, and I just don't want any more. I don't want to see any more bond violations. I don't want to see any more criminal cases. Do you understand? I'm not asking much from you. I want my streets safe. Okay. See you on Friday. All right. So just leave it as it is. Okay. Oh, well, there you go. Okay. I'll sign it now. There you go. We're done. Hey, I just got a BVR on one of your guys. So you want to put her on for Friday? Or let's see when she has court. I don't know. Let's see. That's next Tuesday. Why don't we put her on for, can you be here the 12th? Friday?
Yes.
Okay, I'll send you an email.
And there you have it, a marathon session in a Texas courtroom where judge handled a parade of repeat offenders with a mix of frustration, firmness, and zero tolerance for excuses. Mr. Watson, with 9 cases and a $600 Gucci belt, had his bond revoked after interrupting the judge and denying his violations. The judge told him, "I'm ready to put this baby to bed." Mr. East, a 19-year-old with a stolen gun and no job, was given strict bond conditions and warned that his laughter was inappropriate. Mr. Bex, with 7 dangerous cases in 1 year, was given a GPS monitor, a curfew, and a warning that he's on extremely thin ice. And Mr. Arzu, who refused to exit his vehicle during a traffic stop, was simply told to follow the law. The broader implication here is crucial. The court's patience is not infinite. If you're out on bond, follow the conditions. Don't interrupt the judge. Don't laugh when you're being warned about serious charges. Don't pick up new cases. And don't blame your violations on technicalities. The judge in this session made it clear. I will protect my community at all costs. If I have to make your bond $10 million, I will do it in a heartbeat. If you found this case breakdown as eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We'll see you in the next session.